Colleagues, representatives from the administration, good morning. This is the 9th meeting of the Bills Committee on Mandatory Reporting of Child Abuse Bill. We have a quorum. It's the appointed time. Today is 1st of June, Children's Day. So I hope that members can all put our heads together today and complete the scrutiny of the bill so that it would be a surprise for children. Now, we may not need all 4 hours. If we have to have meetings for 4 hours, I understand it will be strenuous for members, so let's work expeditiously. I will not talk about the public officers in attendance today to save time. We will proceed with clause-by-clause examination. Last time, we were just about to commence scrutiny of Schedule 1. The administration, in response to members' concerns, in particular the DOJ, has some amendments to make. So we will scrutinize both the Chinese and English versions of the bill. On 31st of May, the administration has also provided a response and has followed up on concerns of members, that is, members' letters. I believe the responses of the administration earlier has covered that. We'll see if we need to look at the response in detail in due course. It is also said that the administration was to provide a mandated reporter guide, and the administration has submitted a draft as promised. So perhaps we can also look over the guide today. On the guide, we can perhaps give some suggestions to the administration so that they can flesh out the guide. Dr. Tick. Chair, I understand the procedure of today's meeting. I think we can talk about the guide in the panel on welfare services in due course. But what are we to discuss today? We can perhaps discuss the structure and the representations that the administration should make in the guide. Ms. Lillian Kwok. I am very disappointed that we cannot have the complete guide today. This request was made to the administration earlier, and the administration essentially did not fulfill that promise. We should at least have the complete draft of the guide so as to facilitate members' discussions. As the chairman, I probably did not make it clear. The administration has already submitted the content of the guide. Of course, there is much content that has yet to be fleshed out. But we have a PowerPoint presentation that the administration is going to give. It will last for about 10 minutes. That would be on the structure of the mandated reporter guide. So we will discuss the content, but it will be more about the structure instead of the full contents. If we have to go through the contents, full contents, it would take, I suppose, more than 40 hours to complete. Let's understand that they already have 3 professional consultative panels formed. So we should probably take a more macro approach, Ms. Lin Kwok. We want to make sure we want to facilitate frontline professionals to understand how reporting should work. I do understand that professional consultative panels have been formed, but I just want to make sure there should be a guide in place. And I think with the bill having passed, this would be a problem. Let me first say this. The bill may not pass if we do not even agree that this is the guide that should be put in place. And it would take, as said, longer to complete. Mr. Stanley Lee. So will we look at the mandated reporter guide before we go on to clause-by-clause examination? I think we'll start with clause-by-clause examination. Actually, I'm thinking maybe we should go with the mandated reporter guide first, and then we can go on to clause-by-clause examination because it may be relevant. Yes, Undersecretary. Well, I think because the guide is administrative in nature, we can perhaps deal with the clause-by-clause examination of the bill first. And in fact, we can discuss at future panel on welfare services meetings the contents of the guide. Thank you. Thank you. If members wish to communicate more with the structure and contents of the guide with the administration, I, as a chairman, can organize a non-official exchange session and we can perhaps discuss the guide then. And members, please note that we will soon get to mid-July. Please understand my urgency. I really want to make this happen for children as soon as possible. Dr. Pt1. I understand the chairman's wish. And I think once we already have the structure in place, that should be fine because we can discuss the contents of the guide at a panel on welfare services meeting. I think it would take long if we have to go through the contents. Thank you. All right, thank you. Let's commence clause-by-clause examination, and the administration has submitted a latest draft for the amendments. Undersecretary, please. Thank you. We have submitted CB brackets 2732/2024 brackets 03. These are the latest proposed amendments. We have proposed the new Schedule 1A for serious harm. We have also responded to the concerns of various parties. We will thereafter, having gone through the responses of the administration, we will talk about the structure of the mandated reporter guide. All right, so the administration will start with the schedules, correct? Yes, legal advisor, any comments? None? Thank you. I can see that 3 members wish to ask questions, Ms. Lam So-wei, Ms. Doreen Kong, and Dr. Pt1. I'll assign a 3-minute time limit for members to ask general questions, and then we'll commence clause-by-clause examination. Ms. Lam So-wei, thank you. I actually pressed the request to speak button to speak on the contents of the bill. All right, so let me be clear here. We'll first tackle Schedule 1. Having scrutinized schedules, the relevant schedules, we'll start from the beginning and go through the proposed amendments. Do the two other colleagues agree? All right, thank you. Let's have the administration lead the scrutiny of Schedule 1. Schedule 1, please. Chair, please refer to specified professionals, Schedule 1, Part 1 professionals. So these professionals would include professionals that have frequent contact with children, and these professionals would be in the healthcare, education, and the relevant sectors, and at the education sectors. With these professionals covered, we can have a wide protection web for children to prevent them from being abused. And the Secretary for Labor and Welfare may amend the schedule by gazettal notices if necessary in future. I can see that 4 members wish to speak. I read out the order: Ms. Lam So Wai, Mr. Rincon, Dr. Teck Chi-yun, and Mr. Lai Tong Kwok. 3 minutes per member. Thank you. Ms. Lam So Wai. Today is the 1st of June. In fact, I think the bill originated in 2018 because a girl died and the teacher who knew about this did not report the abuse. Now, I want to ask about Schedule 1A for the definition of serious harm. Is the definition too narrow? Well, the administration will address your question, but we are actually scrutinizing Schedule 1 at the moment. Any brief response from the administration? I think I'll give a response when we get to the relevant provisions. Thank you. Well, we're now on Schedule 1, the 25 categories of specified professionals. Mr. Rincon. Thank you, Chair. I want to ask about 21 to 25. I find it quite weird. So for speech therapists and dietitians, do they not have a list of practitioners with the professional bodies? We're talking about professionals in this list. Can a person only profess to practice dietitian and they would be regarded as a dietitian? Undersecretary. Thank you. For 21 to 25. We have included these categories because they are regarded as supplementary medical professionals and they have registrations with the government. The professional bodies concerned are not statutory bodies. So one can only profess to practice as, for example, a dietitian. So we cannot exclude those who profess to practice as a dietitian. I understand where the administration is coming from, but I think it is not ideal. I also want to complain about the English version. It says here, a person who professes to practice. Professes mean claims that one has a quality of feeling, especially when this is not the case. So one who shouldn't be a dietitian is saying that they're practicing as a dietitian. So the meaning of profess, I believe, is not what the administration wants. We need to have professional bodies, and those individuals should be accredited. If one who is not accredited as a dietitian, we should not include them in the list of professionals. All right, administration, please. Thank you. As for whether one can profess to practice as a dietitian and whether one should be covered, it is the policy intent of the administration because the professional bodies are not statutory bodies. As long as one is registered, essentially one would be covered. And we will review the English version, the English text if necessary. Thank you. Mr. Rincon, any follow-up questions? Well, let me think about it. I'll pass for now. Thank you, Chair. Dr. Pt1. I understand where the administration coming from, but we have some professionals who do not have much contact with children. I still have my doubts as to whether they should be covered. I also want to ask about the relevant schedule. We understand the professionals should have responsibilities, but then for professionals working in institutions, and the institutions have guidelines that would be in conflict with the law, such guidelines will not be regulated by legislation. If one professional is trying to comply with the law but will have to act against the guidelines, will there be any protection for such professionals? Undersecretary, I understand what Dr. Pt1 said, but legislation would override any institution's guidelines. We are thus putting in place an 18-month grace period for the bodies and institutions to amend their own guidelines. Thank you. Dr. Pt1. Of course, we understand that we need to provide guidance for professionals, and once the guide is put in place, the professionals should be aware of what to do. But then right now there is no regulation for institutions to make sure their procedures are compliant with the law. So for professionals working in institutions, it would be hard for them to ignore what is said in the institution's guidelines. Can the law provide some sort of protection, or at least administrative, some sort of protection should be provided to the professionals? Undersecretary, I'll perhaps first invite the SWD representative to talk about the practice at the moment. Thank you, Dr. Tick, for your questions. During the transitional period, we will hold some briefings for institutions. The responsibility of mandated reporting would fall on the professionals. If the administrative guidelines of institutions would be in conflict with such responsibilities, the guidelines would have to be amended. So during the 18-month period, apart from holding briefings, we'll make sure institutions are aware of the legal requirements. Undersecretary, I want to make clear for 21 to 25. These professions are not regulated by law at the moment. Are they all under the registration scheme of the Health Bureau. Yes, Mr. Lai Chong-kwok.
Next, Mr. Lai Chong-kwok. If I may start with some easier questions. Now, for teachers in kindergartens, as well as care workers who take care of children at kindergartens, are they covered under the 25 categories, and which category, please? Chair, if I may defer to the Education Bureau. For kindergarten teachers, you will find them covered by Category 8. A registered teacher or permitted teacher who is working in a specified school, because kindergartens are governed by Cap 279. Thank you. My second question is to pick up the point made by Ms. Doreen Kong. Categories 21 to 25, a person who professes to blah blah blah, other than the problem raised, pointed out by Ms. Doreen Kong, I would like to look at it from another perspective. Now, it says that a person who professes to practice or acts using a particular status. What about if he or she doesn't profess? So I'm afraid the scope would be too narrow. And then you go on to say that somebody who professes to, say, for example, practice as a dietitian. On the mainland, they don't call themselves dietitian. They are called public dietitian. Level 1, 2, 3, or 4. In Hong Kong, you don't need to be licensed. So there's no way that he or she can be caught. By adding 2 more words to his status, he will be outside the scope. Or educational psychologist. I may call myself an educational specialist rather than an educational psychologist. So it would be too vague. So how are you going to resolve this problem? The administration referred to the professional bodies involved. Can you not skip the word professors? Take away the particular term. Now, since you haven't got a definition for such terms, or you can't define it because of the lack of governing or regulatory ordinance, then we can just adopt the ordinary meaning in a dictionary, and that would expand the scope to be covered, and you will add to the clarity. So, Mr. Lai, you are saying that we should delete the words who professes. Of course, it's up to the draftsman to tidy up the drafting. But then take away the word professors so that it will be broader. Otherwise, you are sort of imposing too many restrictions. And the result would be that reporting will not take place. So I'm afraid that you may want to consider my observation. As the chair, my observation is that for these 5 categories of professionals, they haven't got the regulatory schemes, but then when compared with midwives as well as radiologists, I think they have more opportunities to come into contact with children. So I believe that Mr. Lai's suggestion should be given consideration. Health Bureau, please. Thank you, Chair. Thank you, Mr. Lai, for your questions. If I may fill you with the background. Well, for this particular scheme in Hong Kong, there are a few different registration systems. First of all, of course, we have the mandatory statutory registration scheme. You need to be registered before you can practice as a professional in that field. And then we have also got a voluntary scheme. It is an accreditation scheme, and it is not mandatory. And we won't prohibit those who haven't been accredited to practice. And then there are also other voluntary registration schemes arranged by professional bodies. Now, for the voluntary schemes, of course, professional bodies themselves have got a list of professionals. That's quite clear. But then on the other hand, if we only cover members of such professional bodies, then for those who have voluntarily registered with us would not be a fair treatment. So we would like to cover all the practitioners in that particular field. One other point is that our approach is such that, after all, we are talking about professionals, and professionals do have their sort of titles, and that would carry a duty. Say, for example, somebody who professes to be a particular professional, it should carry with this title a duty of care and the duty to report. Our starting point is to afford better protection to our children. Previously, we have already explained that all the healthcare professionals do work as a team. So it isn't quite possible to separate the professionals into two groups, those that come into contact with children, those who don't. Yes, I can appreciate this point. I think many members would like to join the discussion. Next, Mr. Dennis Leung. Thank you, Chair. For Schedule 1, doctors, nurses, dentists, and the ancillary dental workers, dental hygienists would be covered. Now for nurses, we are amending the law, so it's the case with the dentists. So I want the administration to confirm this point. For those specified in the schedule, in particular, dentists under item 2, medical practitioners under item 4, nurses, midwives, enrolled nurses, I want to know whether they are the same as those to be amended in the amendment bill. We have got limited registration as well, so please clarify whether all such are aligned. Administration. Item 2. A registered dentist within the meaning of the Dentist Registration Ordinance. It means that under this piece of legislation, if somebody is registered, then you have to look at Section 2. For the 2024 Amendment Bill, Section 2 is going to be amended so that the definition of registered dentist would be formally registered, special registration or limited registration, etc. So after the Dentist Registration Amendment Bill has been enacted, there will be a change. There's no need to further amend this particular schedule. For item 3, ancillary dental workers, dental hygienist regulations. And under that piece of regulation, we have got dental hygienists. Under the Dentist Registration Amendment Bill, there will be a change, and there would be a category called dental care professionals. It won't come into effect so soon, and we are going to keep the provision as it is until that amendment comes into effect. And then for item 4, we're talking about Section 2 of that particular piece of ordinance, covering temporary, special, limited registration, as well as medical doctors who are exempted from registration. Further on, item 6, registered nurses or enrolled nurses. Now, under Nurses Registration Ordinance, Section 2 gives you the definition covering nurses on the register, and then for enrolled nurses, again nurses on the roll or on the register of enrolled nurses. We propose to amend the definition, so we are going to cover nurses formally registered registered in a who are special registration, limited registration, etc. So we are going to keep the drafting as it is. Chair. Item 19. A person employed by the government as a teacher or principal who is working in a government school. I think that's quite clear. That is, for government schools, both primary and secondary, we are covering teachers and principals. For item 8, a registered teacher or permitted teacher working in a specified school within the meaning of the Education Ordinance. However, when I look up Cap 279, Section 4TAB, it refers to specified schools in the schedule to Cap 279, and there are only 11 such schools. Does it mean that for aided schools, direct subsidy schools, their teachers will not be covered? Is there a loophole there? Or aren't you clear enough here? Education Bureau, please. Yes. I would like to thank the member for his question as to why we are singling out the government schools in item 19. It is because under Cap 279 Education Ordinance, government schools are exempted from the jurisdiction of Cap 279, and therefore item 8 doesn't cover government schools, and that's why we have to include government schools under item 19. The member referred to specified schools. We are referring to specified schools in Part 2 of the bill, and if you look that up, it says that it does not include a government school, a school that only provides post-secondary education, and it doesn't include an exempted school, that is, private schools offering non-formal curriculum, in other words, the tutorial schools. So when it comes to specified school in this bill, it refers to the specified schools in the schedule, Part 2. Kindergartens, care centers, special schools, aided schools, kaput schools, direct subsidy scheme schools, both primary and secondary, and as well as private schools, primary and secondary offering formal curriculum, as well as international schools. We cover all the registered teachers and permitted teachers in such schools. Registered teacher or permitted teacher who's working in a specified school. It doesn't say such teachers other than those working in a specified school. Maybe I can ask the DFJ to take up this question as well, since it is an important question. Well, you don't refer to 48B of Cap 279 for the definition of specified school. Rather, you need to go to Part 2 of Schedule 1. Specified school means a school within the meaning of the Education Ordinance Cap 279, but does not include A, B, and C. So you have to read this particular definition in this schedule. Sorry, I made a mistake. So I need to give the floor to Lillian Kwok because some members have already spoken for the first time. Now, a question about item 19. Of course, government schools are not governed by the Education Bureau, so some teachers don't have to be registered before they get employed, and they are in fact employed under the Civil Service Regulation. Now, for government schools, we have also got permitted teachers, and they need to get a sort of qualification. And then for relief teachers, now, you can stand in as a teacher, and you can also work part-time. So I want to know whether such professionals would be covered. And then for specified schools, in the definition, it says it does not include a school that only provides post-secondary education. For Ivy, my understanding is that currently you would like to define children as those under age 18. Now, for those who study at the level of secondary 3, then the students will be age 15 or so, and then they have teachers, they have counselors. So for such Ivy teachers, again, they haven't got the status as a registered teacher or a permitted teacher. And they may not have a teacher certificate. So I want to know whether they are all exempted and will not be governed by this piece of legislation. Yes, Education Bureau, please. Thank you, Ms. Kwok, for your question. For supply teachers, they are employed by the government. So under item 19, they will be covered. That is, persons who work as supply teachers in government schools. For the case of Ivy, please refer to the Youth College of the VTC. Youth College is the main institution providing courses for S3 to S6 students. So Youth College teachers will all be covered. But of course, if we are talking about schools that only provide post-secondary education, such schools will not be covered. I think the Education Bureau has made it clear, in particular in relation to youth college. For youth college teachers, they don't need to be registered teachers or permitted teachers, and then they will be exempted. So it seems that the schedule itself doesn't make this point clear. So maybe the administration can sort this out so that it won't become a deficiency of the bill. Well, for youth college, you find it in item 18. There is a person employed as a member of the teaching staff or a principal of the youth college of the VTC established under the VTC ordinance. So all the teaching staff would be covered. Ms. Kwok has raised an important point. Now, you have 6 years of secondary education. There is a possibility that you are aged below 18 and yet you are attending university. So if you really want to have a comprehensive protection or safety net, you have to consider this point. Mr. Chu Kok Keung, items 18 and 19. Why can't you item 8 and item 19, can they not be put together? I think they should be side by side, and that will add to the clarity so that either people working in a government school or people working in a specified school. Specified schools don't cover tutorial schools, but then they need to be registered, and tutors may not have teacher certificates. So I wonder if it can be regarded as a loophole. Yes, maybe the Education Bureau and the DFJ. Thank you, Mr. Chu, for your questions. You asked why government schools have to be separately listed. This is because CAP 279 Education Ordinance exempts the government schools. Therefore, we have to provide for government schools and to cover teachers and principals working in government schools. And then for tutorial schools, as to why we have to mention it separately. Well, in fact, for those covered in the schedule, we are covering those who are coming into contact with children frequently and who are under certain form of regulatory frameworks. Well, we believe that students receive indispensable service at formal schools. Most children spend a lot of time or most of their time at formal schools, so they would be covered.
Chair, I beg to differ. Tutorial centers don't offer a formal curriculum, but then there will be fewer students in a class in the tutorial center, so it's easier for the tutorial center instructors to identify a problem. So I think the number 8 and number 19 should be grouped together. Thank you for your comment. We have taken reference from other laws in the numbering, and from 1 to 11, we are ordering them in the order of the ordinances. But then from 12 onwards, these are the professionals who are not regulated. So why there is number 19 is put backward so much. What about the tutorial centers? I still believe that in school, students receive a formal curriculum. And for tutorial center instructors, they come into contact with children only for a short period. So for those working in a school offering a formal curriculum, they come into contact with children more frequently. They are regulated by our laws. So I think covering them should suffice. So a good protection web can hence be offered. Dr. David Lam, I would like to follow up on what Ms. Kong and Mr. Lai said, i.e., those registered under the accredited register scheme for healthcare professions. Like what Mr. Lai said, say if someone professes himself or herself to be a education psychologist or dietitian, and so on and so forth, and you cannot cover them. So I think it's difficult for you to cover them. Maybe they can change their title a bit and then they will not be caught. Can you amend the drafting to add in broadly similar services so that those offering such services would also be covered under the law? So, Health Bureau, please. Yes, understood. Thank you, Member, for your question. I understand where you are coming from, but we'd like to say this. For those on the list, they do carry a professional title. So these are regulated as professionals. So for these 5 professions, we would be using the same yardstick in describing them. I'm not trying to argue with you, but if you look at the titles on the website, there are different kinds of titles, specialists, and then all kinds of different names or titles being used by the profession. So I'm just trying to help you. I want you to widen the scope covered as possible so that you can help the children. If you confine yourself to such a narrow scope, you may still take out prosecution against them, but then it's not you who will make the final decision, it's the judges. So why can't you amend the wording so that you can cover a wide scope as possible? We want to protect the children as much as possible. It's better that you amend the drafting today than actually putting an argument in front of the judge in future. I hope that you can consider it. Thank you, Member, for your question. I understand your point. When we compiled the schedule, we actually consulted the professions on the schedule. Well, different professions may have their own views. After all, this is just a schedule. Like what the LWB said, it can be amended in the future in the form of subsidiary legislation to keep abreast of the times. What you mentioned is true. There are all sorts of different titles being used now. We understand your view, but maybe we can amend the wordings later on in view of the latest developments in the society. What is happening now is that different titles are being used now. Would you just consider my suggestion after you have lost a case in the court? Well, I think they are aware of your views. Next one, Ms. Judy Chen. Thank you, Chair. I can't remember who said this. Maybe it's the SWT colleague. Well, I'd like to follow up on the tutorial centers. I find it very strange. Their response is that, well, children are not staying that long in a tutorial center. But say what the professions we're talking about, say pharmacist, the medical practitioner, well, they will be seeing the children even for a shorter period than the tutorial center instructors. So why are we regulating the former and not the latter? Our intent was to protect our children as much as possible. So I find your response quite staggering. You put the professions who are being regulated in front of the schedule, and then those who are not back at the schedule. And those who profess themselves as a certain profession are still regulated. So I hope that you should cover, say, the tutorial center instructors as well as instructors of interest classes. I believe those should be covered as well. And then the second point is about the term professors. From 21 to 25, you include people who profess themselves to be audiologists, clinical psychologists, dietitians, and so on. I know that because these professions are not regulated by law, so you put professor here. But if we take a reference from, say, other laws like society's ordinance, well, the word used, say, are professors or claims. Would we consider using the same wordings, i.e. professors and claims? So if you're not going along that route, what are your considerations? Let me respond to the first question, and then I'll see if other colleagues can respond to the second one. I understand Ms. Judy's suggestion that as much protection should be afforded to the children as possible. Now, we talk about the pharmacist and radiographer. They may not be seeing the children for a long time, but in their profession, they are well aware of the condition of the children, and they can detect the irregularities very easily. And now in a tutorial center, children may go there after school. Now, normally when children go to, on the days when children go to a tutorial center, they will also go to a school on the same day. So I think the logic for the two scenarios works differently, because for those in the medical or healthcare professions, they would be able to detect the irregularities of a children's physical condition. But then for, say, teachers in tutorial center instructors, they may be contacting the children on a different aspect. Well, let me supplement. If I go by the Undersecretary's logic, well, understand what his logic is. What he meant is that children who go to a tutorial center, well, if they have problems, they would have been identified by the teachers in the school. But then in a school, a teacher has to handle, say, 30 to 40 children, but in a tutorial center, the class ratio is just 1 to several. So it's easier for the latter to detect any problems in the children. All right, in the first round, any colleague who would like to speak but has not pressed the button. Now, for the second round, there are 4 members who have pressed the button: Connie Lam, Teck Ji Yun, Lai Tong Kwok, Lillian Kwok, Judy Chen. 5 members, 3 minutes each. I hope that you can focus on the feasibility of the clauses. If you have questions on policies, that will be dealt with later. Ms. Connie Lam. Thank you, Chair. Undersecretary, in Schedule 1, item 2 and 3, registered dentists and ancillary dental workers, and item 4, medical practitioners. My question is, for, say, interns, dentist interns, are they included? They have to come into contact with a lot of patients, and they have to deal with cases clinically. And should they be covered? What about medical interns? So some doctors are on limited registration, professional registration. I'm not a doctor myself, but are these covered? And then item 3, ancillary dental workers. After the dentist registration amendment ordinance bill is passed, they are not called ancillary dental workers. They're called the dental care professionals. I wonder which bill will get passed first. So is there any new thinking on this? Because in the future, this will no longer be the term to be used. So how are you going to handle that? And then some colleagues also mentioned about items 21 to 25, professionals who profess themselves as a certain professional. Now, as for clinical psychologists, we don't have a registration system. Unlike social workers, well, it took some 20 years for us to set up a social workers registration board, and now it is now being reconstituted. And it's important we have a registration system of a clinical psychologist. So it's not appropriate for everyone to profess themselves to be a professional in that profession. There may be a lot of cases coming up after the bill is passed. I hope that the number of reports will shoot up. So I hope that you can clarify the wordings, who professes. For items 21 to 25, a number of them have been registered overseas and they don't have to get a license in Hong Kong. I got a membership on marital counseling overseas, and they practicing in Hong Kong, and say there are those who profess themselves to be marriage counselors and therapists and so on. And in some cases, their children are suspected of having been abused. So what is going to happen to all these scenarios? For those who are not mandated reporters, if they find or suspect anything and what's happening, they can report to us. It's impossible for us to cover all. We try to cover as many as possible, but then say Ms. Connie Lam referred to, say, marriage therapists and so on. Well, it's impossible for us to include everyone. So, but anyway, if they find that there is a problem, they're welcome to make a report to us. Can I defer to my colleague from HB? Well, we are working on the 2024 Dentist Registration Amendment Bill right now, and after the bill is passed, the dentist registration ordinance will be amended. Now, right now, the definition of the dentist is those who are listed in the general register. But in the future, the definition will be broadened to cover those on formally registered, those on limited registration, professional registration, and temporary registration. So the member is right in pointing out that in the bill, the ancillary dental workers will be replaced by the dental care professionals. This is right. And there will be an update in the ordinance. There will be a new section 2C with the definition of the dental care professionals. That will only take effect 3 years later. So right now, we still have the title of dental hygienists. In the future, when the term dental care professionals take effect, we will arrange to amend the schedule. Now, the member also referred to those who profess themselves to be a certain professional under the accredited registered scheme for healthcare professions, we have tried to explain the point. Those under the scheme should have a responsibility to protect children. Let me put it this way. For the Schedule 1 is aimed at forming a protection web or network. We understand that it's impossible to ask the different professions to do too much. But anyway, we hope that all the healthcare professionals can be put together to form a protection web. We understand that we should not rely on one profession to deal with all the problems. I think there is something common among the concerns of the different colleagues. I think the administration is already rehashing its old points. So we are asking whether we should add in, say, category 26, 27 to cover the tutorial center instructors. Maybe you can address that point. And then also there is a focus or a concern on the wording, so professors. So I hope that the government should not mix up the two issues in their response. And Mr. Lam, if you have any question, the third round. Dr. Teck Chi-yun. Chair, I would like to say something about the 2 points you made. First, how wide the scope should be. I understand that the bill targets the professionals because the professionals have a greater capacity to identify problems. They have a system to handle the problems. They can actually handle issues more reasonably, so they can afford good protection to children. But then the chair referred to whether we should add in more categories of professionals or people to be covered. So anyone who comes into contact with children should be responsible for protecting children. But then when we are legislating, should we be covering a very wide scope? If that is the case, well, it will take us too long a time to do that. And then for the Law Reform Commission, they are proposing another law to protect children. So if we are asking those who have anyone who have contact with children to be responsible for protecting them, then that would be we have to do it with another piece of bill. Well, today is a Children's Day. Let's focus on the issue at hand. And then definition. Can the administration confirm my understanding? Well, definition falls into different categories. Well, the definition of some professions are defined in the law. And then the second avenue is those on the list of the professional bodies. I think these lists are also reliable and credible. And then the third is about the title given by an organization. Well, even if someone doesn't join a professional body, but if my organization hires him or her, I think you are qualified, then I'll give you the title, say a dietitian. So, well, these are the different ways that a title will be given. And then the drafting is relates to professors. The person may be a private practitioner, and well, this profession has to be accountable to the market or the society. So it's all right then for him or her to claim himself or herself as a certain professional. So is my understanding of all these correct?
Undersecretary, I'll let the colleague from HHB supplement my answers. But for the accredited register scheme for healthcare professions, it is very important in the reason why we cover such professionals because there would be people getting accredited through the scheme, and they are essentially subject to regulation. So these 5 professions would have registrants, and we have a list of registrants at hand. So this is why we have included the 5 categories in Schedule 1. As for whether we can add other classes of professionals, if they are subject to regulation, we may include such classes in future. Thank you. Mr. Lighton Kwok. Ms. Doreen Kong had some other commitments, and she asked me to ask some questions on her behalf. The question is again on 21 to 25. When one goes online, we already have an association for audiologists, as well as an association for psychologists, an association for educational psychologists, and an association for speech therapists. I believe the HHB has had communications with the relevant bodies. So if one is a member of the relevant associations, one can essentially be covered. Now, the Secretary may make amendments to the schedule by gazettal notices in future. I understand, however, where Ms. Doreen Kong is coming from. We should make clear the information in the schedule. We shouldn't allow for loopholes to exist for people to exploit, because we want to make sure professionals would have the responsibility of reporting child abuse. So I suggest that we make clear what is supposed to be here. And then, should it be necessary to make amendments, the Secretary may make amendments to the schedule to keep pace with future developments. But right now, Ms. Doreen Kong and I would say the 21 to 25 items are a bit confusing, and it may not reflect clearly the policy intent. So I want the administration to review these to make sure these are indeed valid. Well, colleague from the Health Bureau, thank you. Right now, for these 5 healthcare professions, there are registers, and we have a list of registrants as a result. There are criteria for registration. Even though it is voluntary registration, we have those who registered ranging from 40% to 90% of the practitioners. So this is only a pilot scheme, essentially, the accredited register scheme for healthcare professions. We have been encouraging professionals to join the scheme. In future, we would allow for accreditation of such professionals. In fact, we are already doing that at the moment. I'll perhaps let the Department of Health colleague talk about our detailed arrangements. These 5 professions will be accredited in future. Department of Health. Thank you, Chair. For the accredited register scheme, for these professions, we have allowed accreditation and we have engaged the Chinese University of Hong Kong to provide accreditation to these 5 healthcare professions. But these are not one-off accreditation. The accreditation would have to be renewed. Perhaps every 3 to 4 years. So if we regulate the bodies, it may not be appropriate because they may no longer be accredited in future. Mr. Lai Tong Kwok. I think we shouldn't adopt an across-the-board approach. If there are bodies that are willingly subjecting themselves to regulation, this is ideal. So if people have confidence in the association and you include the association in the schedule, people would agree. If you don't do that, both sides would have their concerns. The Secretary can, in fact, amend the schedule at any time. And should there be future developments that warrant amendments, I see no problem in amending the schedule if necessary. Thank you. Multiple members have expressed their concerns. Let's be frank here. We're not talking about the professional development of these 5 healthcare professions. We are asking whether the wording in the bill would make sure all of the categories, all of these 5 categories, professionals would be covered. As Dr. David Lam said, one may profess to be an audiologist, a clinical psychologist, a dietitian, an educational psychologist. One may earn an income from this. But the problem is whether it is appropriate to include profess to practice. The administration has lost focus and just kept on talking about the professional development of the healthcare professions. So members have problem with the wording that is profess to practice. The administration never gave a proper response. Please do not waste time. Chair. Thank you. We will discuss this after the meeting to make sure who would be regulated and who should be covered in the schedule. And for colleagues, if you think there should be additional categories that should be included, please be specific. If the administration does not accept your suggestions, please consider proposing amendments. I do anticipate even more questions to be raised for Schedule 1A, so please make good use of the time we have at the moment. Thank you. Ms. Lillian Kwok, I agree with what you said, Chairman. We shouldn't limit ourselves to a certain position. So if you are saying one can profess to practice as an audiologist or a clinical psychologist, why not just say the relevant professions should be included? that is, those working in the professions. I also ask, should we include counselors? I believe there is an association for counselors who has tried to apply for accreditation, but then I believe the Health Bureau said counselors are not a healthcare profession and they should be regulated by the Social Welfare Department instead, but the Social Welfare Department said otherwise. We have full-time counselors at schools at the moment, and they would often have one-to-one sessions with students for an hour or more. I'm not sure if the Education Bureau has the relevant figures. I want to ask how many counselors there are in schools in Hong Kong at the moment. Will we even have more dietitians or educational psychologists at school? Well, I think it will be more appropriate to talk about the relevant issues at the panel meeting. Well, I can actually give a summary of members' concerns after all members have spoken. Reverend Peter Kuhn. Chair, I did note before the administration would make use of the expression profess to do something before. So I want to ask, how is the word profess used in other legislation? I hope the government can provide more supplementary information in this regard. Let me also say this. We're not saying that these professionals would abuse children. We're only saying that for professionals who have frequent contact with children, they should be imposed with the responsibility to make mandated reports. So I'm not sure if for osteopaths they are not included in here, and in fact there are many professions like such that are accredited overseas but not so much in Hong Kong. If we have to include all these professions, it would take forever. So should we go with a cruder approach? So as long as one is licensed in Hong Kong or has to undergo registration in Hong Kong, they should be included, otherwise they should not. For example, for audiologists and educational psychologists and so on, for 21 to 25, there is no official registration scheme in Hong Kong, and it has caused a bit of a confusion. So I asked the administration to consider removing these categories. Thank you. Mr. Derek Lee. Thank you, Chair. And it is as Reverend Peter Kuhn said, if one is practicing something and in law they are not qualified to practice something, yet they profess to practice something, it would be against the law. And if we talk about someone claiming to do that while it is illegal, we consider it unlikely in real life because one would have incurred liability should they choose to do so. Reverend Peter Kuhn, I don't think the administration answered my questions. Let me say this. For example, one would say that one is a medical practitioner. In Hong Kong, in Taiwan, they may have a different name in Chinese. So I'm asking the administration to review whether categories 21 to 25 should indeed be included, because one may say that they are an audiologist, but one may not essentially be qualified to practice as such. Should they be covered? And in fact, some members are proposing additional categories. And the list can go on and on. So I think we have to think about, for the categories that would not require registration, whether we should include them. I believe people care for children, but due to various reasons, perhaps misunderstandings, individuals fail to report child abuse. So I think with the bill and the most of the categories included, I believe that should more than cover the professionals that we will need for the reporting of child abuse. We have 2 other members who would like to speak for the second round. We have spent quite some time discussing the issue, so let's do this expeditiously. Mr. Ri Chen. Thank you, Chair. I want to ask also about how we would use profess or claim in society's ordinance. So I want to ask, is the word profess here different from profess or claim in the society's ordinance, or are there any differences? Thank you, Mr. Wallace from the DOJ. We have referred to the medical practitioners ordinance regarding the illegal claiming to be a medical practitioner, and it will be an offense. So we have adopted the wording professes to practice as or publishes his or her name as, and we have drawn reference from the medical practitioners ordinance for this. Will you consider including the word claim here? Well, the word claim came from the society's ordinance. In general, for registrations, we would not allow for one to claim to be a professional, and essentially we would say that profess and claim would have similar meanings. I don't think adding the word claim would resolve people's or members' concerns. Anyway, thank you. Dr. David Lam, I have some very short questions. I think Ms. Lam So Wai's questions were not answered. So for the doctor interns, the medical interns, and dental interns, will they be included? Thank you for the question. Upon the passage of the relevant bills, those on full registration, temporary registration, limited registration, and professional registration would be covered for dentists. As for medical practitioners, we have also included the different categories of medical practitioners on different types of registration, that is. So for professional registrants would not be covered. Well, Right, they would not be covered. So for one who is currently studying social work, a student, they would not be covered when they are undergoing internship, correct? Right, they would not be covered. So one has completed the course and registration, and then one would be covered. That much is clear. I can see that some colleagues have requested to speak for the third round. In order to focus our discussions for Schedule 1, I want to ask, excluding 21 to 25, for 1 to 20, are there any colleagues seeking clarification for items 1 to 20? 1 to 20.
Ms. Lillian Kwok. In relation to the specified schools and government schools, I'm interested in the staff working there. The administration made it clear for interest classes, coaches, tutors, etc., they would not be covered. But then, as you know that you have such a workload for teachers that they have become tutors for interest classes. If they go to a school acting as an interest class tutor rather than a teacher, but they do hold a teacher certificate, will they be covered? For the duty of mandatory reporting, we talk about the professionals in the course of their professional practice, and then they will be covered. I think that's clear. Well, it is about during the course of his or her work as a specified professional. Sometimes we may say that it is a interest group, but then we may be talking about a teacher providing teaching in visual arts, basketball training, etc. They are teachers in its true sense, but then they get employed as a coach or instructor for interest class. Will they be covered? Well, it is only when they are teaching as a teacher. Let me say this once again. If you're talking about coaches and interest classes, then when we have serious harm, of course, we say that when there's serious harm, then there's a statutory duty to report. Well, students would also attend classes. I'm sure their own teachers would have and must have discovered the serious harm. So we believe that that would be adequate. If I may also clarify whether it has to do with whether this person get paid. Say, for example, there is a doctor. He's also at the same time a leader in a new formed group. Of course, everybody would know that he is a doctor by profession, but then he is providing voluntary service. If in the course of serving in this uniformed group, somebody is a victim of child abuse, does he have the duty to report? Well, if he is in the course of his professional practice, then he's subject to mandatory reporting. Otherwise not. But of course, if it does come to his notice, we hope that he will report the matter. And then if we have an NGO and if we appoint a medical doctor to be a voluntary medical advisor, on a voluntary basis, he attends certain activities. He observes that somebody has been abused, and he doesn't get paid as an advisor. So will he be caught? Whether he gets paid or not is not crucial. It's a matter of whether he's providing the service as a medical doctor. So it's a separate issue. So if he's providing voluntary service as a medical advice in a particular activity, so even if he's not paid, if he's a medical advisor in a particular activity, he will be covered, right? That's my understanding, Chair. Well, it appears to me that this is different from the case of teachers in the teaching setting. For those professionals that I refer to, they get paid. Now you're talking about honorary medical advisors. So how come that such people get paid and yet they get exempted? So does it mean that we are talking about specified posts in specified schools? Does it mean that only teachers, school principal, and social workers will be covered? All other personnel will not be covered, right? Sorry, speaker is off mic. Teaching staff employed to work in a school will be covered, and after class teachers, after class activities may involve teachers or social workers, but then this person is asked to lead a particular activity exactly because he is a social worker. So this person will be providing service in the course of his professional practice. Well, we are told that he's a social worker and so he's been asked to lead a particular activity. In some other schools, equally, a person is employed to lead a particular activity because he has got a teaching qualification. So how would you make a distinction? It depends on the after-class activity. When this group or when this person is employed, whether it is specified that this person must hold a teacher certificate and to carry out teaching duties. So it depends on whether his professional status is crucial to the recruitment or employment. Chair, if I may follow up. Now, there may be certain activities and this person is not required to be a social worker to lead the activities, but then this person comes in the capacity as a social worker to take part in the activity. So will this social worker be covered? Does he have a duty? Well, he doesn't. He's carrying out work not of social work nature and not in the capacity of social worker. Just like in the case of doctors, when we have already said that that would not be covered. So the key point is when he's invited to an activity, what is his role? Say, for example, if you're supposed to be a person providing social work in an honorary capacity, so it will be covered. Well, I think that's quite clear. Thanks, Chair. I just want to make it even clearer. In the setting of a school, and this is a specified post, unless it is a specified post, this person will not be governed by the ordinance, right? Administration, any reply? We don't quite understand Ms. Kwok's question. Can she sort of use layman's term to ask the question again? Ms. Kwok, would you like to pause? Everybody, let's take a pause here. Well, we are talking about a particular scenario, but let me ask this question again. For items 1 to 20, for those specified professionals, do you have further questions for the sake of clarification or elucidation? If not, let me sort of have a summary or a conclusion. We don't have further questions on items 1 to 20. Another point is that some colleagues have come up with this concern. There are certain professionals who may come into contact with children very often, like tutors or counselors employed by, say, schools or community nannies or leisure and recreational coaches. Clearly, they are not to be covered by the bill. But then members did refer to cases like sports coaches, counselors, and tutors. Concerns have been raised. Would you like to give an overall reply? Are you going to reconsider the case? Well, we have had 2 years consultation with various sectors and professions. Members may differ in their views as to the scope of the regulatory framework, but we do want to move forward, and then the list can be amended by the Secretary in the light of the latest positions in the society. So we can always take away or add to the types of professions involved here. Let me again deal with items 21 to 25. Dr. Lam, would you like to ask a question about 21 to 25 or something else? Well, I think, well, if somebody is a professional, I want to know exactly under what circumstances will he be covered. Please put your question again. Well, say for example, there's an organization specifying a particular role, specifying a particular activity, and then the professional will be covered. Otherwise, this professional will not be covered at all. Say for example, a tutor for an interest class. Even though this person has got a teacher certificate, but then when this teacher gets employed not because he holds a teaching qualification, well, he may be providing the teaching service 2 hours a day for 5 days a week, he will still not be covered. Say, for example, in the school, we have got a TA. Of course, the school would like to get a registered teacher, but then this is not a requirement for the job. After all, finally, a registered teacher comes, and then he gets employed as a TA. When he's carrying out his work, is he covered? Yes, something like that. We may have a registered teacher, but then he gets employed under a contract teaching interest classes. And in fact, the job requirement doesn't say that he's a teacher. So it's clear, despite his own professional status, he will not be covered, right? Yes. Dr. Lam. Now, for Schedule 1, for our cross scrutiny, I have this suggestion that is less focus on the drafting of items 21 to 25. When it is so drafted, does it cover the statutory duty? And later on, does it create a loophole for enforcement? Members, do you have any fresh points to raise? If not, administration, please. Chair, members' concerns are fully noted by us. And we have also provided you with the various perspectives from the administration. Let's go back to have a discussion as to what we should do about it. What do you mean when you say there will be a talk about this? I think, is it your approach that such professionals will be covered, but you want to avoid loopholes? Indeed, you're right. We want to cover these 5 categories of professionals. As to how we can make it clearer for the sake of protection of children, we want to have a consideration. All right, would it be acceptable to members? Thank you. Ms. Kwok, sorry, I do miss a point. You made a suggestion to administration, but there was no reply. And that's in relation to post-secondary education. There may be students under the age of 18 and could get admitted to a VTC institution. Noted. So it's a matter of whether we should add the 26th category covering post-secondary educational institutions, because there may be students under the age of 18. For the time being, we want to check whether a particular institution is mainly catering for S3 to S6 students. In the case of VTC, we cover the youth college. For other institutions, the number of such young students that are small, then such organizations will not be covered. But of course, in future, if there is a need to cover them as well, we can consider that. Well, if I may, say that for Part 1, Schedule 1, we have covered the cross-by-cross scrutiny of the 25 categories, right? Thank you. Next, Part 2, interpretation. Anything to elaborate? We have already explained this part when we answered members' questions. So unless members would like to have further clarification, I can certainly take up the questions. All right, members, LA, any questions? No? Then in that case, we go to Schedule 1A. I think this is something brand new, covering what's meant by serious harm. So, administration. Members, please take a look of pages 17 and 18 in the English version, serious harm. We'd like to add a new schedule to the bill, setting out the elements of serious harm, and the Secretary for Labor and Welfare may, by way of subsidiary legislation, amend the schedule to add certainty to the reporting threshold. It will also add to the flexibility of amending the schedule so as to align with the latest thinking of the society. There are 4 categories: physical harm, psychological harm, sexual abuse, as well as neglect. Well, we would like to add this list of elements in response to members and the sector's concern about the lack of or inadequate certainty. In this way, we can concisely and precisely identify the scenarios requiring reporting, and then we can avoid under-reporting or over-reporting. We have made reference to 3 points. First of all, we have got the mandated reporter's guide. And during the consultation, we've listened to the social welfare sector, educational sector, welfare sector, and the health sector. And they have talked about the scenarios and the analysis. And then the professionals have had experience of dealing with local cases. We have had previous cases, and we've looked at overseas and local legislation, which contain the relevant provisions. We are keeping a degree of flexibility. The SLW can amend the list so as to reflect the latest thinking of the society. Well, for serious harm, we have got 4 major categories. Let's focus on the first group, physical abuse. 3 members would like to ask questions: Lam So Wai, Tik Chi Yun, and Lilian Kwok. 3 minutes each. Thank you, Chair. Undersecretary, for the first item, under serious harm, I would like to look at the definition. I'm grateful for the administration for taking on board our views. Serious harm, I just wonder whether it is still too limited, and it appears to be a bit absurd. Now, we want to impose a statutory duty on the professionals to report. But then for professionals, I think they should be more sensitive in identifying the victims. I'm afraid you're setting too high a threshold. You talk about endangering a child's physical health. you talk about loss of consciousness, impaired consciousness, bleeding, etc., etc. What about bruises all over the body? Or what about abrasions all over the body, a lot of bleeding? Or you have a lot of marks or scars on the body? Will they not be covered? So please give us a reply. Thank you.
Before the administration responds, I hope that you can at the same time look at item 4 as well. And that is clause 4, that is also in the risk of suffering a serious harm. Administration, please. We're talking about mandatory reporting. We've been talking about serious harm all the time. So in response to members' views, we have taken a look at cases of serious harms that have happened before, and then we consolidate them into certain principles. What about the member asked about, say, the scars and bruises all over the body? We have to draw a line somewhere. So that's the line we're suggesting this time. And some may suggest that the line be drawn lower. But even if the reporting threshold is not reached, we still welcome reporting of those cases. And the personnel have to be looking at the relevant circumstances, whether there is a great risk involved. So we will not be just looking at the scar, so to speak. In clause 4, we also mentioned some other scenarios which point to a risk. So we would not just be looking at whether there are scars to decide on the reporting threshold. So, Undersecretary, we are talking about some 20 professions, and not every profession has a high sensitivity level as to whether a report has to be made. Well, I know what clause 4 is about. But you're talking about wounds and scars all over the body. And you have to explain clearly to the different professions. Say, midwives, optimists, and other professions, they have to be well aware of what you are looking at. I think the definition is a bit too narrow. I know that only when you see serious harm would you be mandated to report. But not every profession has the same level of sensitivity. So should they report or not, who bears the responsibility? I think you should be very clear on that. Yes, I believe they have heard Ms. Lam's views. I think it's about striking a balance. So should we be describing the harm as serious as this, or should we be describing it, some other ways? Dr. Teck, we have to protect children. Well, there is a definition of serious harm. Well, there might be, say, moderate level of child abuse, a very light level of abuse. Well, when we discussed this, we said that we would not tolerate any kind of child abuse. And the government is proposing an amendment today. It seems that we are just concerned about serious child abuse. So if it is just a moderate level of abuse, say a few scars, it's not serious, but it's still child abuse. And if the professionals don't report it, then they are okay under the law. So is this what we aim to do in legislating? So does it mean that only under serious harm cases should the professionals be mandated to report? So if it is just a mild child abuse, it's all right for the professionals not to report it. Is there a loophole there then? Now, if professionals are only mandated to report these serious harm cases, are there any other measures that we can make up for, say, the less severe cases? If a profession, so we are talking about under what circumstances will the professional be held criminally liable for not reporting a certain case. So we are talking about a serious harm, and also there will be 2 levels of penalty depending on the level of neglect that you are involved in. So we've been talking about this at the very beginning of this Bills Committee's work. There are 2 levels of penalty. So we would look at the level of neglect of the professionals in meting out the penalties. Now, what about mild child abuse cases? Under the current mechanism, we still encourage them to report it. So that has all been discussed at the very beginning of the Bills Committee's work. We were very categorical in saying that we only covered the serious harm cases, and professionals are mandated to report those cases only. If not, they will be held criminally liable. Well, maybe I have forgotten something. I think our principle is very clear. We like to legislate to protect our children. There are indeed serious harm cases, but there are still so many light child abuse cases. So under the bill, that means that I can ignore those. But then as a profession, no, we still follow up. But we want to legislate to protect children. But then you're only covering the serious harm cases here. And then for the many child abuse cases that we see every day, those are not covered. I don't recall what you said in the beginning, but our really aim is to protect the children, and what you're doing doesn't really match my expectations. Well, members may recall that we didn't have Schedule 1A in the beginning, and a lot of members had asked what serious harm is. Well, especially members who don't come from this welfare sector or the education sector, they asked categorically for a very clear description in the bill on serious harm. And now we have the definition here, and then you are questioning, oh, we are only reporting on the serious harm cases. I think we have a consensus here that we would like to raise awareness on child abuse through legislation. Maybe a child doesn't suffer from bone fracture, but then I am alert to the fact that maybe he is under some sort of child abuse. I might not necessarily report to the police. I have different tools to resort to follow up on the case. So this is a sort of positive thinking that we should embrace. Now we're talking about threshold. Then if you set the threshold too low, then, well, the professionals may panic. So different legislators may have their own yardsticks, but I hope that we can come to a consensus and forge a consensus. I believe that there might be a loophole somewhere, but anyway, I think we should go along what I suggested. Ms. Lillian Kwok. The government has made some amendments. You have included wordings like or like to broaden the scope. And you also said that in clause 2, part 2, you said that you should, the child is at the risk of suffering serious harm. I think that is good. But then for Schedule 1A serious harm, I'd like to ask a question. You talked about endangers child's physical health or life-threatening. I have come across students who have a lot of scars resulting from retin strips, and the skin is very bad, and he's not under his life is not endangered. But then that happens frequently. But that case doesn't fall under the life-threatening definition. So, what happens to this case? Is it just considered a mild case, as what Dr. Tick said? Well, you said here clearly it is related to muscle or tendon damage. SWD, please. We will follow up on all child abuse cases, but if we're talking about criminal liability, then that's what this bill is aimed at doing. So we hope that the professionals can detect such cases as early as possible, and we can follow up duly. And Ms. Kwok referred to a case which may not reach the threshold as set out in 1A, serious harm. But after the bill is enacted, the 25 professionals will be trained up, and there will also be webinars to be organized. And we will also present some scenarios and do analysis, and under what circumstances will mandating reporting be required. Maybe the case doesn't involve serious harm, but we will not neglect those. There is a decision tree, and there is an analytical framework, and that is to say, even if the case is not doesn't involve serious harm and no mandatory reporting is required, we would ask the professionals to follow up and report based on the guide. So more professionals can be involved in the cases. And if cases attract criminal liability, the police will follow up on the relevant investigation. So, Chair, can I present some views to the administration? Because in 1E, you talked about burn or body service, or burns resulted from cigarette butts and so on. Maybe it's not life-threatening. And say if we spot serious harm or scars on the skins, why don't we consider them? So please consider including those. A to G are just examples. They included but not limited. Well, let's focus on the first sentence. Endangers a child's life or harm that requires urgent medical treatment. We cannot be exhaustive here. So 1 to G are drawn up based on the principles set out in the first sentence, including but not limited. But you didn't say that. Say so. Well, let me say this. On 1A, item 1, you want to say something, but you have not pressed a button. Is there anyone who is like this? Chu Kwok Keung, Tang Fei, Reverend Kuhn, Dr. David Lam, and Mr. Lai Tong Kwok will let us speak for the first round. Chair, in response to the administration's reply, I would like to follow up. Should I be pressing the button? Yes, second round. Let me make this arrangement. After Mr. Lai Tong Kwok has asked his first round, we will take a short break. Mr. Chu Kwok Keung. In Schedule 1A, there is a definition of serious harm, 4 items: physical abuse, sexual abuse, and also neglect. These are written out clearly. But then psychological health or development includes only 2 items: mental derangement and prolonged psychological trauma. The drafting is not as good as those contained in the EDB's administrative guidelines. The definition is the harm to the child's psychological health, his emotional development, and or the carer's interaction model with the child and other extreme incidents covering cognitive, emotional, and social development. Well, that is a lot clearer. Very often, for psychological health damage or abuse, maybe it's or prolonged verbal abuse and social segregation and so on. Will that lead to mental derangement or prolonged psychological trauma? Not necessarily. So I think we should also say something about social, cognitive, and emotional development. Should those be included? Well, my arrangement is this. Let's focus first on item 1 here, but that's okay. Any response on Mr. Chu's point? Can I defer to the SWD? Thank you, Mr. Chu. In 1A, we are talking about serious psychological harm or abuse. It's 2A, and that includes mental derangement and prolonged psychological trauma. And mental derangement means a prolonged mental disorder and prolonged psychological trauma. And that means the child suffering threats to his psychological health. Normally, it isn't caused by a single incident. Normally, the perpetrators will inflict serious harm on the children, causing prolonged and sustained trauma. So we would like to include the serious and prolonged trauma. I think the way it is written is not comprehensive enough. So the several points as suggested, should they be included as well? Any response, please? Yes. We will take reference from the EDB's guidelines, and maybe in the mandated reporter's guide, we can also be elaborate on this further. Mr. Tang Fei. Thank you, Chair. I agree with what the chair said. We have to draw a line somewhere, serious harm or harm, where it's a give and take situation. The amendments contain a lot of examples describing what is serious harm. It includes them, but are not limited to it. I accept that. I agree to what Ms. Connie Lam said. Different professions may not, whilst knowledge on these types of phenomenon differ. I'm not saying that we should treat the different professions differently. But the administration should provide basic training to the different professions. Let me cite a very simple example. Say for 1C, an injury to any internal organ. A simple example, I have handled 2 cases at the school while suddenly a student, its nose was bleeding. But then the the healthcare professional knows exactly what is happening. So you have to provide training. You should contain this in the guidelines. And then fracture to any bone. Normally it's difficult to detect it visually. A child turned pale, and then he was sent to the hospital, and we know that he's had some hereditary problems with the heart. Well, we don't know what causes the serious harm. I mean, sometimes it stems from some hereditary diseases, and sometimes the child suffers some internal injury because of, say, playing sports. And sometimes involves bullying on the campus. Maybe it has nothing to do with the parents. So the first response of the school to a serious harm cases is to call an ambulance and send the child to the hospital. And then the school will consider whether I should report the case to the police, because I don't know the reason, whether it's because of parents abuse of him, or is bullying, or is the child suffers from any hereditary diseases or some other reasons. So anyway, we would call the ambulance, and then we have to decide on whether we should call the police.
I thank Mr. Tang for his questions. I understand his concerns. But let me say this. For clause 4, as we said, as long as one has a reasonable suspicion, one should report it. We do not ask professionals to be knowledgeable about everything. We want to cast a wide net and have a comprehensive protection web for children. We are not asking professionals who are not medical practitioners in the first place to be proficient with medical knowledge. In fact, we are only asking that an accident not caused by the neglect of a responsible person of the child or the child himself or herself or any other child that should not be reported. Otherwise, professionals should report any such cases. Mr. Tang, any follow-up questions? Well, I think those in schools would have the most contact with students or children in general, but we are exactly the ones who would lack the requisite knowledge. I hope that there will be more information in the guide, because we will not be able to tell visually most of such harms as shown here. And there is really no way for us to judge how such harm is made. Well, we will refer to the Education Bureau's guidelines and make sure there are comprehensive guidelines for those working in schools. Thank you. Reverend Preacher Kun. I would first like to thank the administration for listening to the views of various members. As the chairman said earlier, many of those in the field or the relevant sectors were concerned about how to determine the degree of harm. And we are also not aware, I should say this, we do not want to see over-reporting either. But we do face some difficulties. As members mentioned, for those working in schools, they may have a very different knowledge set compared to medical practitioners, and I see here the definitions here for serious harm would mostly be medical. I understand that it may not be easy to spell out everything, but we have to make sure professionals are assured that they won't breach the law inadvertently. But we also want to make sure those working in schools should know that even if the report may not be substantiated in future, they should report such cases. Under Secretary, we thank the member suggestions. We'll see how we can improve the drafting of the provisions. I can see that Ms. Elizabeth Court has also pressed the request to speak button, so I'll let Ms. Elizabeth Court speak as well before we take a break. Dr. David Lam. Thank you, Chair. It is just that we do understand a criminal liability may be incurred if one does not report it. So essentially, we are encouraging people to report potential child abuse cases, even if they are not substantiated. So I also want to ask, for those who have reported the mild child abuse cases, they would still be protected by the bill, correct? I also want to ask about one. The administration said it would be including but not limited to. But then not limited to is not said here. And I want to ask if it is really what they meant, because if you mean including but not limited to, the list can go on forever and ever. I have tried to come up with different ways of doing this. You can perhaps add more categories, but a potential category will be a potential threat to one's life. I think we would be striking a good balance with the addition of such category. So for someone who has made use of a needle that is undisinfected or maybe even used to prick children, this can cause serious infection, of course, but it has not been included in the 7 categories here, A to G. But this can endanger a child's life. If you can include the serious cases, I would prefer it this way. If you're just saying it could be including but not limited to, I am actually concerned that the list can go on forever and ever. Thank you. Undersecretary. Well, for Schedule 1A, that is in 1, it says any harm that endangers a child's life or harm that endangers a child's physical health and requires urgent medical treatment, including. We would make sure we would refer to this very first sentence. The 7 categories would just be examples. I'll let my colleagues supplement my answers. Well, for the other cases, we would of course also follow up on that with multidisciplinary conferences. For example, we would follow up the child abuse cases in general. We would formulate a welfare plan for the child. If there is any criminal offense involved, the police will investigate. I'll also let the DOJ supplement my answers further regarding drafting. Thank you. In relation to the drafting legislation in Hong Kong Styles and Practices Guide, including would mean including but not limited to. And as the Undersecretary said, the focus of this part would be the very first sentence, that is any harm that endangers a child's life or harm that endangers a child's physical health and requires urgent medical treatment. Thank you. Dr. David Lam, any follow-up questions? Well, I would say that you can add the expression threat of life here. Well, the administration will take that into consideration. Well, we'll have Mr. Lai Tong-kwok speak, and then we'll take a break. Mr. Lai Tong-kwok. Thank you. We have now amendments to have a new Schedule 1A to talk about serious harm. The administration really has to step up publicity efforts on this in future. Because we have been talking about this bill a lot, we may have forgotten we already have a mechanism in place to tackle child abuse. With or without this bill, professionals would have to follow up on the child abuse cases. They may not have criminal liability, but they do need to follow up on these cases. So I ask again that you should make clear this in the relevant codes of practice. And it is in fact said in the long title that you require certain professionals to report suspected serious child abuse cases. And it was during our discussions that we found the definition of serious harm unclear, which is why the administration proposed this new Schedule 1A. I do support the administration doing this. But now questions from members are saying that would this cover everything? And I will now remind members that this schedule would may be amended in future by notices in the Gazette, and such would be subsidiary legislation that would have to undergo vetting by the Council. Let me also say this, as the administration said, for one, the important part is any harm that endangers a child's life or harm that endangers a child's physical health and requires urgent medical treatment. So it would require medical assistance. It doesn't matter where the medical treatment is done, hospitals or schools or otherwise. So there are, after that, examples to illustrate this very first sentence. I think this much is clear. We, of course, can't have an exhaustive list. So these are the prominent examples of the very first sentence. If in future we have observed that there are cases that are getting more prominent and are not included in here at the moment, then the schedule would have to be amended as soon as practicable. Upon passage of the bill, I believe the administration would be prepared to make amendments in the midterm if necessary to the schedule. So as I said earlier, while I do agree with what other members said about this schedule being not perfect, it does not cover everything. It may not be comprehensive enough. Of course, we can raise suggestions now, but I'm just saying it does not stop here. The process is continuous. The administration would be liaising with the professional bodies, and if they found that something was missing, these can be added later. And I think we have achieved our policy intent with what we have here. Well, I think most of them were comments, and I'll ask the Undersecretary to give a brief response. Thank you. We take note of the suggestion. We'll take a 5-minute break. Thank you.